Here I have brought another video on MCQs on Chhattisgarh Excise Act. So this is part 2 of the Chhattisgarh Excise Act MCQs. I already covered around 50 questions there in part 1. So here question number 51. Which amongst these is correct? The statement. When A says when an offence under the act has been committed but the offender is not known, it's known the case to be inquired by JMFC and he shall pass order for confiscation of article seized. Option B says magistrate is bound not to pass any order of confiscation with regard to a case in which collector has initiated proceedings of confiscation even if intimation of such proceeding not received by the magistrate. C. Proceedings by collector with regard to confiscation under section 47 capital A are performed only when quantity of liquor exceeds 5 bulk liter. So considering option A, when offence under the act has been committed but the offender is not known, the case to be inquired by JMFC. So it is incorrect option. It is not the JMFC but the excise authorities are there. The court cannot take cognizance or inquire or pass orders in such a circumstance where the offender is not known. So it is the excise authorities. You can see the provision. B says magistrate is not bound even when the information of intimation is not received. This is also incorrect because here if the court is not to pass any order on confiscation only when the intimation has been received. So here intimation of proceeding is not received, even then he is not bound to pass any order as to confiscation. This is wrong statement. And then comes proceeding by collector with regard to confiscation under 47 capital A are performed only when the quantity of liquor exceeds 5 bulk liter. And this is a right statement as per the provision there. It is to be done only when the liquor exceeds 5 bulk liter quantity. So this is correct statement. Answer is C. Now comes 52. Confiscation articles as per section 47 capital A of the Act after seizure must be placed before. So after seizure of confiscated articles must be placed before collector as per the provision. So collector is the right answer because you can refer to section 52 of the Act, and here it is stated that articles liable to be confiscation, liable to confiscation, and those articles which are seized there as per 52, it is the collector before which this article must be produced. So this is collector, option A. Now 53, order of confiscation under section 47 capital A can be passed by. So it is again the authority which can pass the order of confiscation. So it is options are collector, commissioner, excise officer, officer not below the rank of district excise officer. All of these authorities are excise authority as per the Act, but answer is A, collector, as per section 47 capital A and subsection 2. So this is A, which is the correct option. Next question is appeal against order of confiscation under section 47 capital A can be presented before. So it is section 47 capital B, which is the provision for appeal there, and it is the options are collector or any other officer authorized by state government, commissioner, court of session. As per 47 capital B, it is collector or any other officer authorized by state government. So the interesting thing is that the order is passed by the order of confiscation can be passed by the collector, and even authority before which appeal can be filed is also collector. But there is option also or any other officer authorized by state government. I could not understand this provision, but if you understood it, why so collector can be the appellate authority when he himself is passing the order of confiscation. So let me know about the same. Next question is which among these is correct with regard to power of appellate authority under section 47 capital B. Options are during pendency of the appeal against order of confiscation, stayed the order of confiscation. B says pass order allowing interim custody of seized article, and C says decide the appeal within 30 days. So and D option is A and B both. So if you read the proviso after section 47 capital B subsection 3, there is a proviso which says that the court can pass order allowing interim custody of seized article, but it cannot stay the confiscation order. So here it's option B which is the correct option, because appeal to be decided within 30 days is not the provision. Appeal can lie before the authority that should be filed within 30 days. So it's option B which is the correct option. Next question is, what is the remedy provided under the Act against order of appellate authority? So when appellate authority, which is under 47 capital B, and after appeal, what is the provision there? So A says revision before court of session, uh, appeal before excise commissioner, C said no remedy available, and D appeal before JMFC. So the express provision is 47 capital C, where it is provided. Option A is the right answer. Revision before court of session is the remedy after appellate authority has passed order in appeal against confiscation. So it is only about the confiscation proceedings which were going on and against which the appeal has been filed as per 47 capital B, and it's 47 capital C against before the court of session. The revision can be filed against the order passed by the appellate authority under 47 capital B. So next question is, limitation for filing appeal under section 47 capital B against order of confiscation is 30 days, 45, 60, 90. So it is 30 days from the order. A is the right option. Next question is, offences under the Act can be compounded by. So is it collector, commissioner, JMFC, A and B both? Section 48 is the provision, and both A and B is the right option. Collector and commissioner both can compound the offences. Next question is, what offences are as per the Act can be are compoundable? What offences are compoundable? It should be the provision. As per the Act, you can remove R. What offences as per the Act can be compounded? So option A says all the offences under the Act. B says offences under section 37, 38, 38 capital A. C says offences under section 37, 38, 38 capital A, excluding the cases of admixture of an intoxicant with noxious drug. And D says offences 37, 38, 38 capital A, 45, 46. If you read the provision properly, it's subsection 1 of 48, and it provides option C as the correct proposition there, the right statement, because it excludes the cases of admixture of intoxicant with noxious drug. So if it is the case that there are intoxicant includes noxious drug, it is found out, then in such cases it is not compoundable. So C is the right option. Next question is, amount or penalty in lieu of composition of offences under the Act can be. So A says with not exceeding 20,000 rupees, B says not exceeding 10,000 rupees, C says it cannot be compounded with money, and D says punishment as to 3 months as plea bargaining in lieu of composition. So as per the provision, it's 10,000 which can be maximum the amount for composition. B is the right option. Next question is, power to enter and inspect places has been conferred on. So A, excise commissioner, B, excise officer not below the rank as prescribed by state government, C, collector, and D, all of these. So as per 61, it's all of these. All these authorities can inspect places and enter as per the provision. Section 51 is the provision. Next question is, power to arrest without warrant to seize article liable to confiscation under the Act authorized to. So it's option A, any police officer or excise officer not below the rank prescribed by state government. B says any excise officer or any police officer not below the rank prescribed by state government. D, district excise officer, and D, any police officer not below the rank of SI. So this is a provision, it's a question which shows the importance of reading the provisions properly, because you see the A and B are very similar and look-alike option, but both are different, as the police officer and the excise officer both are the authorities which can do the same, but who is it, the excise officer, which should not be below the rank of prescribed by the state government, or the police officer? So as per the provision, it's option B, any excise officer or any police officer not below the rank prescribed by the state government. It's not A, it's option B is the right option. Next question is, power to arrest without warrant under the section of the Act authorized to. So here the another question inside a question. So it's section 53 is the section which gives power to arrest without warrant, and who is the authority? So as per the section, it's the options are any excise officer not below such rank as may be prescribed by state government, and in case of police officer, district excise officer, and police officer, or both the authorities, excise or police officer. But as per the provision, it's option A, any excise officer not below such rank as may be prescribed by state government. Option A is the right option. Next question is, in what category of offences no anticipatory bail can be sought under the Act? Option A, offence under 49 capital A, offence 34 subsection 1 A and B when the quantity exceeds 5 bulk liter. Offence under 34 1 A and B, both A and B. So as per the provision, it's both A and B, and D is the right answer. Only these two offences are offences on which no anticipatory bail can be sought. So this is expressly provided in the provision. Section 59 capital A is the provision. Next question is right of default bail in case of offence under section 49 capital A arises. So A is on expiry of 120 days of detention and no report of complaint filed. B says on 60 days, C on 90 days. And obviously all of these cannot be the answer. But as per section 59A, and there are provisos, the proviso provides that in case of offence under 49 capital A, it's option A, 120 days of detention and no report of complaint filed after 120 days, then it's the default bail right arises in favor of accused. And the same question for 34, offense under 34, 1 A and B, where the quantity of liquor is more than 5 bulk liter. So for this offense, when the right of default bail arises, is option A is 120, 60, B and C 90 days. And the right answer is 60 days, B, in case of 34, offense under 34, 1 A and B, and there the quantity of liquor seized is more than 5 bulk liter, and that is also an offense on which no anticipatory bail can be sought, as well as only those two offenses are non-bailable in nature, otherwise all the offenses are bailable. So B is the right option. Next question is which amongst these is correct? A option is offense under section 34 subsection 1 A and B relating to landa and handia made from rice or millet, and out still liquor made from mahua committed by ST member in scheduled tribe member in scheduled tribe areas shall be non-bailable. B is court may take cognizance of any offence on the complaint or report of any individual. D says all offences under the Act are non-bailable except as provided in section 59 capital A. And D says none of these. So none of these is the right option, because all the remaining options are incorrect. Here the the court shall take cognizance only on the report or complaint of some officers expressly provided there in the Act. And A is in this scenario where the liquor is prepared by this process provided in this option, it is bailable in nature. It's not non-bailable. And option D, all offences are non-bailable except as provided in section 59 capital A. So it's just all offences are bailable in fact, and except provided in 59 capital A. So as provided in 59 capital A, there are two offences which are non-bailable. Other than those, all offences are bailable. So D is the option, the right option. Next question is special provisions as to scheduled area under the Act was introduced in. So there is a chapter 8 capital A which was introduced in 2013. So A is the right option. Next question is a special exemption from certain provisions of the Act in scheduled areas extends to. So the chapter 8 capital A was introduced in 2013, and what is the extent to whom this Act applies, what category of people this Act has extension to. So this is the option. A says all residents of scheduled area. B says only scheduled tribe member of scheduled areas. C only scheduled tribe and scheduled caste members of scheduled area. And D only scheduled tribe members of any area. So if you have read the provision properly, the barrack properly, it's option B which is the correct option. Only scheduled tribe member of scheduled areas, and that is the right option. Only to those people who live in the scheduled area and belonging to scheduled tribe, those people are only to be given benefit of this special provision, special chapter. Next question is the limit for possession of country spirit in scheduled area shall not exceed. A says 5 liter, B 10 liter, 15 liter C, and D 3 liters. And this is for per household, and it is explained in the provision that household means the family members and all the family members in a household. So the amount which is the quantity of liquor which is limited that can be in possession of each household. It's option A which is the correct option, 5 liter per household. Next question is which authority may reduce down the limit to possess the country spirit by the ST scheduled area, by the scheduled tribe people in scheduled area. Option A is Gram Sabha, B Gram Panchayat, C state government, D A and B both. So As per the Act, the authority which can reduce down the limit to possess the country is spread by the scheduled tribe members of schedule area of schedule area. It's Gram Sabha, option A. Next question is manufacture of country made spirit in schedule area shall be for the purpose of. So it's option A says for domestic consumption only, B but not for consumption at religious festivals, C for consumption of only for scheduled caste members, D all of these. The correct option is option A for domestic consumption only. In B, but not for consumption at religious festivals. So it's the wrong option because the possession is specifically also provided in the Act for consumption at religious festivals area. So option A is the correct option. Next question is which authority shall give effect to the orders passed by Gram Sabha? A says Gram Panchayat, B collector, C Gram Sabha itself, D none of these. So it's Gram Panchayat which shall give effect to the orders passed by the Gram Sabha, and also it is provided in the provision that SGO can may help the Gram Panchayat in executing the orders. So, but the effect to be given by the Gram Panchayat. So A is the right option. Next is which amongst these is correct? Option A says import and export of intoxicant is completely prohibited under the Act. B says no bail can be granted for offences under Section 49 capital A. D, denatured means unfit for human consumption. And D says all of these. So option C is correct option because import and export of intoxicant is not completely prohibited in the Act. It's just some restrictions. It is provided therein that pass is required for import and exports. So this is incorrect option. B says no bail shall be granted for offence under 49A. It's also wrong because bail can be granted, but only anticipatory bail cannot be granted. Regular bail is always allowed for any offence there in any act. And C says denatured, unfit. So this is the right option. Denatured means unfit for human consumption as defined in the definition. So C is correct option. Next question is rule making authority under the Act is state government, excise commissioner, central government, state government in consultation with the Gram Sabha. So option A is the right option. State government is the authority, the rule making authority under the Act. So I hope it was helpful for you in preparing for examination. And if you want to see more such videos, then please subscribe the channel. Thank you for watching.